I will take this 2 more minutes for introducing Professor Manuel David Maceno. Professor, I think that my pronunciation is okay for your name because mine is Indian pronunciation. Yes. So Manuel David Maceno is a professor of law and the data protection officer at the Polytechnic of Beja, Portugal, where he is also a member of the coordination of lab UBNet, computer security and cybercrime, and of MESI, Master of Computer Security Engineering. Besides, he is a member of EDEN, Europol Data Protection Experts Network, as well as of the International Advisory Boards of the International Review of Law, Computers and Technology, and of the European Journal of Law and Technology. Now, these two journals are kind of heaven for researchers like us, where we target to put our papers. I welcome, on behalf of United World School of Law, Karnavati University, Professor Manuel David Maceno, for delivering your lecture, for holding this webinar on data protection, data security from the EU, as well as from Asian, Indian perspectives, from comparative perspective. Professor, we welcome you from our Karnavati University, UWSL.
Thank you. The pleasure and the honor are mine to have having the opportunity to delivering a lecture more than a conference. I thought my intervention as a lecture, an academic, from an academical point of view, instead from a political one, or even as a policy approach. We are all trained as lawyers, so we think from a legal point of view, and I had to make choices. For having for an hour, maybe a bit more, I'm warning you. I was not able to, well, to concentrate the subject for 40 minutes, I suppose. But as I was trying to say, there are 4 policy, legal policy and future legislation EU documents, 2 from the board and 2 from the Commission. I thought as addressing the documents, but that would do for my students at the end of the course, having in mind the full framework of data protection and data security. So I supposed that that knowledge is not even expectable from students, even brilliant students from India. Therefore, I prefer to focus, not excluding, of course, the policy documents that will be referred and addressed, but focus on the legal foundations of data protection related to health and location. The main problems are the processing of health-related data and the processing as location and tracing of mobile devices. Therefore, in the sense that these are the ways that institutions tried to deal with the subject relied on the previous established basis. So you will be able to later think critically both on the European and I suppose also to address critically in Indian policies and laws. Well, I'll try to share. Please tell me if you can see it. To share my Professor De Barati, I need you to allow me to share. Okay. Thank you. Can do it now. Can you see it?
Yes, sir. I hope other participants can also see it.
Yes. So, in the sense that, well, this presentation was made from scratch. I had several contents, but not with this perspective. So I prefer to do something new, even from, well, an aesthetical point of view. First, legal framework. I'll try to go as fast as possible, trying not to repeat what you have on the screen. So we have to rely on two acts. GDPR, the General Data Protection Regulation of 2016, enforceable since May 2018, a bit more than 2 years, and within the same framework, Directive 2002/58 EC as updated, amended at 2009, the so-called e-privacy directive. This directive had connection with the 1995 directive on data protection that preceded GDPR, but now has to rely on the regulation, on 2016 regulation. By now, should be already in place an e-privacy regulation, but the legal procedure stalled some months ago, and without a consensus, or at least a viable majority for voting. So we don't know exactly where if the privacy regulation will get through. But anyhow, one regulation, one directive. For non-European students, I should add, have to, that a regulation is an act that is applicable directly to any citizen, company, member state, or legal body, public, private, is a law. Instead, a directive states objectives, indicates a date for transposition, and each member state has to adjust, adapt, if needed, its internal laws to the directives. And these directives are mandatory, are under supervision by the executive branch of the European Union, the so-called Commission, and are enforceable through the Court of Justice of the European Union if they are not implemented or are not properly implemented in terms of delays or content. And sometimes there are shortcomings. The member states do not transpose directives fully, not just in time, but fully. It happened many times, unfortunately. So these two ones. Besides, data protection has a role, and well, may say now, a strong position after the Treaty of Lisbon, after 2007, 2009. Within the may say the constitutional framework of the European Union, we have the Treaty of the European Union, the Treaty on the Functioning of the European Union, and the Charter. In each one of them, specifically at TFEU and at the Charter, we have provisions on personal data. These provisions might be applied also by the court. So they are not just political, think as a full constitutional role, starting with Article 16 of the Treaty on the Functioning of the Union. Everyone has the right to protection of personal data concerning them. And then, well, competence, attribution of competence to, or legislative competence to the European Parliament and the Council. Also, well, the idea of control by independent authorities is a main point, and we'll see how relevant it is. Also, the Charter. The Charter addresses the subject in two ways. Follows a more traditional line at Article 7, privacy, strictly speaking of privacy. Everyone has the right to the respect of his private life and communication. Attention to communication. This has to do mostly with the content of communications, with telecommunications, or as are the wording now, electronic communications, but also metadata regarding telecoms. But apart from this privacy, we have protection of personal data itself, following what we've just seen at the Treaty on the Functioning of the European Union. Everyone has the right to protection of personal data concerning him, everyone, him or her. And the standard, the material standard, are at paragraph 2. We might even say that with, well, a dense, thick case law, just paragraph 2 would do. Such data must be processed fairly for specific purposes on the basis, on the consent of the person concerned or some other legitimate basis laid down by law. Keep it in mind. And then the right to access to data collected and the right to rectify it. So, in some countries in South America, they call it habeas data, as habeas corpus. The right on data as a right on the body, on freedom. Yeah, please, later. I would ask, I have to, someone asked for, so, excuse me, I would answer you.
Yes.
By the end, but someone asked me for textbook on the subject, so I cannot stop. I cannot stop delivering a lecture for in order to give guidance on bibliographical issues. Please, I'll do it at the end.
Yes, all participants, we will take your questions after the session is over. And please mute your microphones so that Professor can continue. Yes, sir.
Oh, excuse me, just. No, excuse me, I will return. I had to answer the phone. My 88 years old mother phoned me, and I just had thank you, mother. I'll talk to you later. And I trying to, well, no more sound, no more people. Okay, so I'll get back to the lecture. Okay. I think you can, dear professor, are you listening now? Well, is it okay?
Yes, Professor, we can see the
Okay,
screen.
thank you. Thank you. Thank you. Just to be aware. Okay. The Treaty of European Union would be the base. Please shut your phone, your microphones, please. And at Article 2, we see that now the Union is founded on the values of respect for human dignity, freedom, democracy, rule of law, and respect for human rights. Besides, we have at Article 6, paragraphs 2 and 3, receptions. Receptions regarding the Charter from 2009 was previously a restatement. Please shut the microphones. Was a restatement of previous laws. I need to shut. Okay, done. Well, okay. I had, excuse me, but I had to shut the microphones. Well, telling me. Well, the has a reception at stating that the norms. It's difficult when we stop to restart, but the norms at the Charter had the same level as the treaties, but more than that, it receives the European Convention for the Protection of Human Rights and Fundamental Freedoms that shall constitute general principles of Union's law. This provision has a long history, mostly within the case law of the Court of Justice of the European Union, but that will not be possible to address now. And besides, and having to do directly with our subject, have the case law, not one of two courts, the Court of Justice of the European Union, that, well, that always acted from the beginning of the 60s, from the, well, when the European Economic Community was created. The idea is that consolidation of a different legal order, and a legal order with a paramount position regarding member states' law. And I point out, and I've studied most of them, even, well, 3 of them I wrote on the subjects, 1, 2, 3, 4 of them, judgments that took into account the new framework of data protection rights after 2009, after the Treaty of Lisbon. Digital rights Ireland having to do with surveillance, digital surveillance from member states, even for the purpose of fighting against serious crime and terrorism. Google Spain having to do with control and surveillance by the private sector, Schrems, Breyer, till Peter Novak. And I stated the concerned member states. So if you students, you just, well, Google C23912/12 would find all the content related to the cases. And since you also follow English approach, that would be important for you. The European Court of Human Rights, in place since 1959, implements the Convention for the Protection of Human Rights and Fundamental Freedoms, usually known as the European Convention on Human Rights of 1950, and has to do with the Council of Europe. Council of Europe is a different international organization that has no economical purposes, is in place since the end of the 40s, has to do with the international political framework after I'm trying to check the sound of this Mac. Okay, done. Okay, and well, I was setting. They have to do with the international political framework after World War II, and it seems besides the reference made here, Article 6, Paragraph 3 of the Treaty for European Union, all member states of the European Union are also member states of the Council of Europe. Here, since it's in the 1950, states that everyone has the right to the respect for private life and correspondence, and the limits, the accepted restrictions of paragraph 2. Please pay attention, because they are quite relevant for our subject. No interference by a public authority on the exercise of this right to respect of privacy, except such is in accordance with the law, first, and is necessary in a democratic society in the interest of national security, public safety, or the well-being of the country, for the protection of health. Here, health standard, allowing the restriction of privacy. Also, the court, the European Court, this European Court of Human Rights, delivered already in this millennium several judgments having to do with data protection, even data protection, for instance, surveillance, or health access to health data, or the conservation of DNA. But just pointing out that within the Council of Europe, there is also a convention for the protection of individuals with regard to automatic processing of data of 1981 that is not implemented through this court, as the court only enforces the convention. But in any case, the court applied the provision on privacy, having in mind now data protection. They had no other way of doing this. Well, focusing on EU law, with the GDPR. Well, it applies to personal data and information related to an identified or identifiable natural person, the data subject. Pay attention to identifiable, directly or indirectly, by reference to identifiers such as location data or an online identifier, an email number, or an IP code would do specifically. More. Besides, we have provisions for special categories of personal data that once were called sensitive data, namely data concerning health. And we have a definition, a legal definition of such data. Data related to physical or mental health of a natural person, which reveal information about his or her health status. And processing, in the sense that for processing, we take any operation or set of operations which is performed on personal data or on sets of personal data. Think, or just take a look, or that for processing, the legislator means from collection to destruction, to erasure and destruction. All these technical operations are deemed as processing, though are relevant for our purpose. So, but I have to shut sound. Okay, better. Okay, so requirements. Processing should be lawful only if and to the extent that at least one of the following applies. Data subject has given consent. This has to do with the charter. We are talking about mostly a right to informational self-determination, or otherwise, and there are more possibilities, but pointing three that had to do with our subject. Besides consent, processing is necessary in order to protect the vital interests of the subject or another natural person, or processing is necessary for the performance of a task carried out in public interest. at recital 46, and I would invite you to read the recitals. Due to principles as of European Union law as subsidiarity, every EU act is preceded by a long list or a long test of recitals, where the legislator explains why and why, and do it. Besides, not being, well, law, the recitals are so relevant that sometimes issues that were where there was not a full consensus to be drafted into articles, the provisions are placed in recitals. And the court, the Court of Justice of the European Union decides and applies articles, applies provisions following recitals. Well, this recital, at recital 46, it states that processing of personal data based on the vital interest of another person should in principle take place only where the processing cannot manifestly based on the legal basis, and think sometimes of processing may serve both important grounds of public interests and vital interests. And one of the examples is for monitoring epidemics and their spread. And we are dealing with a pandemic, a larger than epidemic. So, on these grounds, the controller, and we have here the meaning of controller, natural legal person that determines the purpose and means of the processing of personal data. The controller shall implement appropriate technical and organizational measures in order to ensure and to be able, I emphasize, to be able to demonstrate that processing is performed in accordance with the regulation. Is the responsibility connected with accountability. Therefore, the controller should implement these appropriate measures, which are designed to implement data protection principles, and we'll see a bit of these principles, such as minimization, in an effective manner, and to integrate the necessary safeguards into the processing in order to meet the requirements of the regulation, protect the rights of data subjects. This has to do either when the processing is sought in draft, and also when is implemented, had to do with so-called data protection by design and by default. The same happens or has to happen regarding the security of processing. It states, Article 32, that the controller and the processor shall implement appropriate technical in order to ensure a level of security appropriate to the risk. Please have in mind the ideas of pseudonymization and encryption of data, and the ability to ensure the ongoing confidentiality, integrity, availability, and resilience of processing. Well, besides and also having much to do with our subject, as we are dealing with the processing of on a large scale of special categories of data, namely with health-related data, or on a systematic monitoring of a public assembly area on a large scale, data protection impact assessment has to be carried, as it is likely to result in a high risk to the rights and freedoms of natural persons. Meaning also that besides the controller, even public policy solutions had to be preceded by data protection impact assessments. Well, but what I mentioned, the processing of special categories of personal data. This processing, in principle, is forbidden. There is a generic prohibition. This moment, we think mostly about health data. However, the prohibition, according to Article 9, paragraphs 1 and 2, shall not apply if the data subject has given explicit consent to processing of such data for one or more specified purposes, having in mind the idea of specified purposes, or processing is necessary for reasons of public interest in the area of public health. And as examples, protecting against serious cross-border threats to health, or ensuring high standards of quality of healthcare. But this has to be done on the basis of European Union or member state law that provides for suitable and specific measures to safeguard the rights and freedoms of the data subject. See that it's acceptable within the framework of the regulation, but with excuse me, but I have to shut. I had to shut the sound. Well, I was, as I was trying to deliver in order to address these problems, to member states may maintain or introduce further conditions with regard to the processing of data concerning health. And another rule, the norm that in the end is also relevant for our subject, is that decisions, automated individual decision making, including profiling, the legislator deals with artificial intelligence, shall not be based on special categories of personal data, namely regarding health-related data. And here I also left the actual definition of profiling. In short, and we should have in mind the principles that are enumerated and somehow explained at Article 5. The control should be responsible for and be able to demonstrate compliance with accountability, lawfulness, fairness and transparency, purpose limitation, data minimization, accuracy, storage limitation, with integrity and confidentiality. These are the paramount references. Besides, GDPR also allows for restriction of rights from of the rights of natural persons, personal data. And does so following by the word the EU Charter on Fundamental Rights, Article 52 on scope and interpretation of rights and principles, and European Convention of Human Rights, specifically, as we've seen, Article 8, Paragraph 2, right to respect for private and family life. So it states that union or member state law may restrict by way of legislative measure, not an administrative provision, the scope of the obligation and rights when such a restriction respects the essence of the fundamental rights, first requirement, rights and freedoms, and second, is a necessary and proportionate measure in a democratic society to safeguard other important objects or general public health. So we have again.
Moto G5 plus இருக்குல்ல. போயிட்டு பார்ட்டிசிபென்ட்ஸ் போ. உன்னோட பேர் வந்து இல்ல இங்க மோட்டோ G5 plus இருக்கு. அத கிளிக் பண்ணிட்டு ரீநேம்னு போடு.
Then
email எங்க வரும்னு தெரியல.
The Article 23, we have several standards that would limit the scope of restrictions made through legislative measures. But let's go on. I would appreciate this is that person goes to talk about
email வேற எங்க கொடுக்கிறதுன்னு தெரியல.
Okay, I think I was able to do it. Well, institutional pronouncements during the pandemic. The first took place on the 19th March by the European Data Protection Board. This board has as members a representative from each national data protection authority, plus the European Union, meaning that what the board decides will be the criteria to be applied by each national data protection authority, even for applying fines and huge fines, as at the GDPR. The sense that this, now it's a statement. Well, that statement, let's see, the guidelines would be 21st April, would be more relevant on, well, a mandatory stick point of view. But the board started with a statement. With the statement when, let's say, everybody, almost everybody was nervous, persons were afraid of the virus, were afraid of a widespread surveillance by states. So the board needed to stand and state, well, let's say, the rules of the game. First, that GDPR does not prevent health authorities and employers, since one of the main problems was the control by employers of their employees at workplaces, namely having to do with higher temperatures. If an employee might be signed out if getting through fever, that could be COVID-19. Well, the GDPR, as someone there to say, oh, it would be impossible to fight the pandemic with data, as the GDPR would prevent it. No, it said no, even with health-related data and location data, the GDPR would do. For instance, in employment context, it said, well, employers should follow national workplace health and safety regulations and public health rules. Also for the vital interest of their employees. It's relevant, this reference to Article 9, paragraph 1, I and C, because this had to do with public health and vital interests of people in general. The board excluded, this is important because to say so, as there was a sort of polemic around this, but not as Article 9, paragraph 1, H, that has to do with, well, workplace safety during normal times, saying that here we are dealing with public health, general interests, not with the maybe abusive control of workers by masters, by employers. So the rules, the general rules on data protection of workers as in national laws would not have to apply. On the other hand, the statement dealt with the processing of electronic communication data in special for location, and reminded that the privacy directive allows national implementing laws of the directive to restrict the scope, I missed the D, of the provided rights. And again, with the wording we almost already know, when such restriction constitutes a necessary, appropriate, and proportional measure within a democratic society to safeguard national security. Well, it says national security. This provision was related to intelligence or fight against crime. However, the board interpreted this also with a connection to a pandemic as a menace to national security, and had put an emphasis on anonymization of data as well as minimization with strict proportionality requirements, saying that, for instance, for the designing of public health measures, governments, the administration do not need to know where a given person is. Just having to know if, for instance, at a place, for instance, a beach or a park, how many people are there? If there are too many that could enhance the spread of the disease, or for people, if people stay at home, it's possible to see that or to find out through this location data of cell phones or tablets that if people tend to stay at home instead of going around. And remember also remember something and say, well, this criteria already present at the charter, at the European Charter of the Fundamental Rights of the European Union, and as we know and already know, at the European Convention of Human Rights, are these criteria that might be at national regulations are under judicial review. This was also polemic, but was stated clearly at a decision of the Court of Justice of the European Union by December 2016 at Teletus Veris. And that the powers, legislative powers, having to do with such restriction having regarding the safeguard of national security did not remain within the realm of member states, but are now at the level of the union. Summarizing by me, EU data protection laws as respecting its core principles in the rights of data subjects as much as possible. Then we have guidelines. Guidelines, and these are as much mandatory as they could be, based on the GDPR, to be enforced by each national supervisory authority, enhances and specifies the contents of the statement, including the role of GDPR on the e-privacy directive, about the use of location data, and goes beyond the statement. The statement relied on electronic communications data from electronic communication operators, telecom operators, but here also from information service providers, meaning over the top services, such as this one, such as Zoom, or such as WhatsApp or Messenger or other service not able to be qualified as a telecom operator. And saying location for the use of location data, consent of user is needed. So the norm would be asking for consent. People downloading and using freely location and tracing tools, including, well, mostly think about apps at cell phones, unless a national law introduced a derogation. But this derogation had to follow the requirements we've been dealing with an emphasis on anonymized data. Yes, if the processed data should be anonymized and not be available to anyone, including state agencies, even, and I have almost a page on that in the guidelines. Well, now there are artificial intelligence that are able to repersonalize, to de-anonymize data. But, well, that would lead to the conclusion that these anonymization technologies should be robust enough in order, if not to prevent, at least to turn repersonalization or de-anonymization as difficult as possible. And for not contract, I was amended by the system. This contact tracing, the board point out the scope and functions of principles, just purpose limitation, just for that. No more, just for that data is gathered and used for only this purpose, minimization, just for the least personal data needed with privacy by designing privacy by default requirements that we addressed a little bit. Besides, other principles, fairness and transparency, together with storage limitation. Oh, sunset clauses, meaning that when the pandemic is over, the data should not be kept, should be erased when no longer necessary. As the people and in general, and also the board has everybody's afraid that governments as well as big companies would try to keep this data for other purposes. Least of them the control of people, either as citizens or as consumers. The same for integrity and confidentiality had to do with security, identification of mobile devices being pseudonymized, with also a consistent, robust pseudonymization, so that even when tracing should be that would be a device name, let's say carrot, but there would be no easy, at least easy way of attributing carrot to an email number, or even less to the name of a natural person. And the retained data and data should be retained in each device, not centralized, should be encrypted. Every storage system might fail. So at least as encrypted as Article 34 of GDPR points out, would prevent any, well, illegal access to be pointless. Also, transparency has to be assured, including auditability of the algorithms by independent experts. For its place, the Commission, the executive branch of the European Union, started with, at 8 April with, let's say, a very ambitious recommendation. The idea was to build up a union toolbox, for the use of technology and data to combat and exit from the COVID-19 crisis. Well, just remember this, that according to the Treaty for the Functioning of the European Union, recommendations have no binding force, but they could be often politically relevant in the sense that the Commission has always in mind the general interest of the Union, not the interest of each member state or a group of member states. And this recommendation, of course, if you look with this code, C 2020-2296 final, would find it in every official language of the European Union. Well, it advocates for a common pan-European approach, forcing building of a tool of practical measures, practical, technical, and legislative measures to be created by the convergence of member states, European Union institutions and agencies. And it also has a model for a framework, a legislative framework for mobile applications. Well, we are about to finish now. Then, about a week later, more than a week, the 17th April, the Commission realized that pan-European approach would not be feasible, and instead adopted a communication. Again, communications are not binding for member states. However, the Commission has powers to supervise, to oversee the implementation of EU law. And what we have here at this communication is a list of requirements that, according to EU law, both the treaties and the GDPR and GDPR regulation and e-privacy directive, it's quite close to what the board had approved, but says, well, these are the requirements. From now on, member states will go each one their way if they say so, if they They decide so, but member states are not free to do whatever they want. They need to follow the minimum standards set at EU level. Okay, I'm done. I don't know. Well, okay. And I'm ready for the questions.
Yes.
It took just about 1 hour as.
But this was really very informative, Professor, especially for the sunset rule. I mean, many of us are actually, what should I say, that we have downloaded, I mean, majority of us, we have downloaded the health app, which was mandatorily told by the government. And your explanation about the entire privacy and also data protection mechanism made us understand many things. So I make this platform open for any questions from the participants. You can either ask yourself or you can put it in the chat. We will make it to reach it to Professor. Any questions from the participants?
Do not be afraid. I do not bite. I'm not putting grades on you. I'm not putting grades on you.
Okay, I am getting a question, I think, from a student who says that what should be the best book, textbook on cyber law, internationally speaking?
I don't know. I also read that question. Well, I'll think a bit about it, because what would be best for me, meaning focusing on EU law and Portuguese law, would not be suitable for you. Or there are, for instance, there are many from the US, as the world didn't exist, just US, and following US law. I see what might be relevant for EU, for the, high level Indian students. But possibly I would ask Professor Basu that he would be much more aware of the need. It's funny, but at Facebook, I had the memory with Professor Basu 11 years ago.
Yes.
At Northern Ireland. So we are getting old.
Okay, I have got one more question from one more participant. And this question is, how far the data can be protected during this pandemic situation?
I could not understand you because of the noise.
Yes, there was some sound was coming. How far the...
excuse me, I'll done. You may now, that person.
Yes, how far the data can be protected during this pandemic situation?
The what? Excuse me. The.
This is from Dr. Vijay Lakshmi.
I could not understand one word.
Okay, you can hear me, Professor?
Yes, yes, yes.
Okay. This question is from Dr. Vijay Lakshmi, who asked that how far we can protect the data during this pandemic situation, because you have explained the mechanism, you have explained the convention, you have explained the policies, etc. And personally, I am very much interested now in doing more research on the sunset clause. But what Dr. Vijay Lakshmi is asking is that how to protect the data, whether the data can be protected. I mean, is it just a paper tiger?
No, but it's sense of data protection or data security.
Yes.
It's not the same.
Okay, okay.
It's
so is it like, yes, Professor, yes.
Data protection has to do with processing. The data security, that it happens to be my research issue is data security within data protection. So I would say encryption.
Encryption. Okay.
Encryption. And first, well, a decentralized mode.
Okay.
If data is gathered at, let's say, telecom operator systems, it would be difficult for those operators not to share information with governments. Difficult.
Okay.
Yes, and legally or illegally, either legally or illegally. If data is within our own devices, that would be something else. Besides, even being possible, the EU does not point to a mandatory downloading and applying of these devices.
Okay. Professor, I have one more question from another participant who is asking that many persons and many researchers from all over the world, especially for the data security researchers, are asking that Zoom app is not a very safe app. But almost everywhere, especially in India also, we are holding sessions, we are taking classes through Zoom app. Do you think that it is really unsafe app, or do you think that it is safe?
Well, we also have been using Zoom for 4 or 5 years. For us, it's not. We were one of the first. Our national agency for information technology in higher education research got a license from Zoom maybe 5 years ago, and we are using it. There are shortcomings, namely having to do with the chat and links, but maybe the Zoom by now is after a few upgrades, security upgrades, is not worse than the others. So pay attention, just pay attention. Maybe it's not a good idea to put, and I prevented myself from doing that. Do not put active links in your chat. That bug seems to have been addressed, but in any case, be attentive. It's not worse. It's not worse.
I have another. Yes, yes.
Yesterday, excuse me.
Yes.
It seems that Zoom erased the accounts of people that had a meeting on Tiananmen. So that's a problem of not technical, but even a political problem.
Yes.
If Zoom is complying with the requests of the Indian government, might also comply with the requests of Chinese government, might also comply with the requests of other governments. So maybe privacy is not fully safeguarded against third parties as governments. So if you have sensitive data, better not use Zoom.
Absolutely, absolutely.
And excuse me, this has not to do with us as professors. So students, if you want to perform cyber sex, do not use Zoom. Just kidding.
Absolutely,
absolutely. So
this is very necessary information, because we do understand that the youth are using Zoom app for their personal usage. So that should be stopped. It is really very informative understanding. Professor, I have one more question from another student who is a final year student. The student is asking whether Google and Apple apps are safe during this pandemic.
I'm not sure. I would not. We did not. Well, I'm from law. I'm a lawyer, but at our lab, we did not evaluate the app. So I would not. Well, if you may find second and third and assessments, mine would not be better. We did not address it.
Absolutely.
In the sense, I could repeat what other people have said, but we do not have a direct evaluation of the soundness of that app. But anyhow, what this app was is supposed to be compliant with US law. Some people already say that, well, they do not follow at least fully the higher requirements of EU law. We Europeans, we know that, well, the IT, we are a bit hampering the development of IT technology for having too high legal standards. But that's the European way.
Yes.
There should be the American way, the Indian way. Well, India no longer belongs to the British Crown, so you have for a long time now, you have the freedom to follow your own path. I would
Absolutely.
not dare to criticize Indian government. It has to do with Indian people. You are the largest democracy in the world, for better or worse. That's up to you. So you have your own standards. And
Absolutely.
I would not dare to say that the European standards would be better for India. Our standards, they took a long time to, well, discuss. Just think that the proposal for GDPR was presented at January 2012, and it took until late April 2016 to have the final text adopted. So there was more. Well, there were more than 1,000, few thousands amendments at the Parliament. So it took a long time, and that was the possible consensus at the European level. Well, US, they are following their path. India, now I have very close connection with Brazil. I'm helping a bit because their data protection law is about to be enforced from August.
Yes.
Well, but different cultures, the different laws, but we are all humans. And besides, we are Indo-European. Yes.
Okay.
Yes.
One more question that I just had, Professor. This is about how does the breach of data affect the ordinary citizens?
Daily.
Yes. How does the breach of data affect the ordinary citizens?
Video or breach of data?
Sorry?
You said breach of data or?
Breach of data. Yes.
Oh, okay. No, it has to do. It depends on what data malicious third parties have had access to. For
Yes.
yes, if for instance, if an insurance company knows too much regarding your family, you may not have well, a car insurance or a health insurance. If people know about your banking data,
Mhm.
in a few minutes you might be ripped out of money. It has to do a lot of things.
So this
And
is
I'm
connected with how you are
well,
using the data, right? Right,
yes, and
Professor?
what data? Well, for young people, teens, they in general they do things that later they regret.
Absolutely.
Yes. Well, I have children, and I know that sometimes they do things, and they, for instance, they put photos at social networks with friends. That in a few years, when they would look for a job, they would prefer not having that photos. Now, and and the breach of that's those are the perils of technology. So it's it has to do with the government or institutions, but mostly which each one of us to control our data. That's the idea of informational self-determination, controlling our own
Self-determination.
data.
Yes, yes.
Yes, it has to do with it's a decision from the beginning of the 80s, the census decision by the German Constitutional Court, that without a specific mention at the fundamental law of Bonn, the 49, the German Constitution, stated that based on the human dignity reference at the Constitution, that each person has this right to decide about their own related personal data.
Absolutely. Absolutely. So thank you, Professor. I have taken so much time. I mean, it's for my personal gain also. And I believe that the participants who came here, joined us, also got some valuable information, knowledge from Professor Manuel David Maceno.
I just hope that they found it well, not boring. At least.
No, at least I can understand that it is not boring, because the questions that I'm getting, definitely this is not something which is like, it looks like they're very much interested. Now,
so I'll be available for Professor Debarati.
yes,
yes. Well, at better times we may repeat it, or even delivering, well, not
yes.
just 1 hour lecture, but
yes,
a larger body of lectures.
And Professor Manuel David Maceno is a very good friend of mine on Facebook. So if any of the participants have got any query for any sort of international treaties on like data protection, etc., sir is there on Facebook. So sir, I think definitely you can quest the like whatever informations they would come with, you can answer them, sir. So on behalf of Karnavati University, Unitedworld School of Law, I thank Professor Manuel David Maceno for giving us your valuable time. Thank you all the participants and all the esteemed colleagues of mine, students of mine. Here I end this session. Thank you all for giving your valuable time, and especially again, Professor, I know that this is a weekend, and even though it is during pandemic, there is no weekend for any of us, but still then it is a weekend. So enjoy your weekend, sir. And to all the participants, see you again for our next session. Thank you, sir. Thank you, Professor. Thank you, sir.
See you.
I think we can end the session here. Yes. If any one of you have got any other questions, you can contact us, and also we will be letting you connect with Professor if you have any other questions on this session. Thank you, sir.
Yeah.
Sir, you can now